5, 4, 3, 2, 1. Learned Sessions Judge considered the law on the subject while reversing the order of the Judicial Magistrate. I have perused the order of the Judicial Magistrate as well as the order of the Sessions Judge reversing the said order of the Magistrate. A perusal of the order of the Judicial Magistrate shows that the magistrate went beyond his jurisdiction in discussing the evidence at the enquiry stage by giving a finding that the evidence of the witnesses is found to be unbelievable and that the complainant could not have taken a job with the petitioner accused as he was a total stranger to her. Learned Sessions Judge in the revision rightly found that the magistrate at the stage of inquiry could not go into the pros and cons of the evidence of the witnesses and that the settled principle of law is that the court is only to find out at the stage of inquiry whether the materials prima facie make out an offence, and if prima facie an offence is shown to have been made out on the allegations, then the magistrate is only expected to proceed with the inquiry and frame a charge, and that at that stage he cannot discuss the evidence and give a finding. The words sufficient grounds for proceeding found in section 203 CRPC clearly shows that all that the magistrate is expected to do is to see only whether there are sufficient grounds for proceeding against the accused for an offence, and at that stage he cannot go into the truth or otherwise of the allegations made in the complaint. The magistrate should also keep in mind that the standard of proof required at the stage of inquiry is not the same which is expected of the complainant during the trial. If there is prima facie material to support the allegation which will show sufficient grounds for proceeding against the accused shown in the complaint, then the hands of the magistrate is tied and he cannot but to proceed with the case and dispose it of according to law. The sessions judge rightly held that the Cr.M.P number 1511 of 2010 magistrate exceeded his jurisdiction by dismissing the complaint under section 203 CRPC after discussing the evidence produced before him. Relying on these two judgments, learned senior counsel appearing for the petitioner submits that the learned courts have erred in not taking the cognizance in spite of the prima facie materials available in view of the solemn affirmation as well as two inquiry witnesses. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.